Bama Law, and you're watching Bama Law. I am first time ever streaming on Rumble and YouTube. I really hope this works. I can't guarantee it, but let's hope it does. You can at least find me over at Rumble. It's Bama Law, same as YouTube. Let's get her done. Let's see how it goes. Tonight, I can't even talk. Tonight, I'm going over the recent TROs, temporary restraining orders from the federal courts on the, Trump administration, President Trump, which has been beyond an overreach of the federal courts to the point that they need to be literally destroyed and done away with. I've had it. I'm done. This is it's out of control. We have few select judges literally dictating the will of the people. And there's nothing we can do because no one's standing up to them. It's time for President Trump to turn into Andrew Jackson and say, you know what, Judge? I tell you what, you've got your order, enforce it. You ain't got no U.S. Marshals. Guess what? That's under the DOJ. It got reorganized. It's no longer the Supreme Court's sole authority. That's the oldest law enforcement in the United States. It's no longer it. Nobody's going to do anything. What are they going to do? Issue a warrant? They're not going to do anything for the president. They can't. Enough is enough. These stupid judges are trying to import back deported aliens. You can't do it. He has the exclusive jurisdiction to deal with foreign policy and anything to do with immigration as far as the execution of the law. That's it. He's executing the law. So there's two. I'm trying not to go too long, but one of them is fairly long, TRO. The other one's fairly short. Let's get started. Now that I've gotten my bitch session out of the way. All right, the first one is out of the United States District Court. Let me get my little highlighter here. Hang on a second. See if it works. Yes, sort of. That's weird. Yeah, it sort of works. Okay. United States District Court, Northern District, California. Northern District of California, out of the what we call the Ninth Circus, because every damn thing they do is a fruitcakey loop of Barnum and Bailey. It's the American Federation of Government Employees, the AFL-CIO, fantastic group of people, useless, don't do anything for anybody, especially the Postal Service. They don't do nothing for those folks. So anytime you think that the postal employees get special, I don't know, whatever, they get hosed. I did it briefly. It is the hardest job I ever had in my life. They will fire you for breaking your damn foot. Not even joking. You don't get hurt. Your first 90 days, you don't get hurt. You might have a compound fracture. You better freaking put a stick to it, tie some rope around it, and keep running your damn route. So there's still issues with them. There's still issues with all these. But I had no idea how many unions there were for the government. It's an insanity. It's way out of control. They don't even need it, for Christ's sake. They've got representation. They already have it in Congress. So we've got the AFL-CIO, the American Federation of Government Employees, the United States, it's OPM, Office of Personnel Management. Let me see if I can get my microphone a little bit better. Is that better? Hopefully everybody can hear me. I got new earphones. I still look freaking ridiculous, but honestly, I think they're not as loud. Like I can't hear myself as well. Let's see. Is that better? That's a little bit better. Turn the mic volume up. So we've got United States Office of Personnel Management. The personnel management, it's called OPM. Anything that excluding Postal Service, they're this weird quasi-separate group. If you get a job with the federal government and you're a GS-rated employee, you're going to be under OPM. You might interview, obviously, with the people or the group that, let's say, Army Corps of Engineers, civilian. You're going to interview with them, but you're going to go through OPM. All your paperwork, everything's going to go through OPM. Retirement packages, your paychecks, taxes, etc. It's going to go through OPM. So they're the ones that have said by presidential order, executive order, remember your first 2 years on an federal employee, dude, you're on probation. you don't even have a right to work, really. You could come in and they go, man, you were a minute and a half late and you suck. You're fired. That's it. You're done. Is it going to happen? No. Well, I mean, I'm sure it could, but it's not going to. In this instance, the president has sole authority to say, you're all fired. We don't want any temporary. We don't want anybody on probation. We're done. We're hiring. We're doing a hiring freeze. That's it. And so they have attacked the president via OPM because OPM has to execute those orders. So the orders start. This is a fairly short one. It's like, I think it's only 2 pages. It's fairly short. The hearing on a preliminary injunction will proceed Thursday, March 13th. So we've already had it. I don't have the result of it. I'm trying to remember when I got this. I think I got this the 14th. And I didn't, I did not have the judge's final order. This is just the TRO. The government argues that March 13th evidentiary hearing and any depositions, why is it doing that, are unnecessary in light of OPM's compliance with their TRO and their unwillingness to convert the court's TRO into a preliminary injunction. The problem is that plaintiffs seek broader relief than was provided by the TRO now in place. So even if the court must rule based solely on the record, there we go, submitted during the TRO proceeding, it will do so on or before or on or shortly after the March 13th hearing. So they're saying basically, I'm going to get around to it. It's just, it may take me a day or so. It's going to be close. I wouldn't be surprised if it's already come out. I would not be. I should have checked, but I just didn't. So bear with me. The other one, I believe it's more of a permanent TRO. We're reading this together really for the first time. I kind of heard about it, kind of looked at it and went, oh, yeah, that's okay. I need to look at this, but I haven't gone through it like prior with y'all. Let me go back to here. I always forget. I forgot it again. Dang it. My name's Chris. I am a licensed attorney in the state of Alabama, and I am not your attorney. I do not provide legal services. There is no client confidentiality in this. We are not going to have a relationship in that term. I am just spouting BS. Well, not BS, but my opinion, which may be considered BS. And that's it. And we're having fun. That's all. I'm giving a legal analysis and a probably really slanted view. Okay. That's just what we're doing. So please do not take this as any kind of a legal, anything I say is legal advice. Go seek counsel in your state or wherever you're at, territory, and get that taken care of. Okay. All right. Defendants next argued that the testimony, why have I lost my little pen? Come on, give me it back. Let's go. Here we go. There we go. Defendants next argue the testimony of acting director Ezell should not be compelled. Now, the defendants, remember, that's OPM. That's technically, let's just call it President Trump. Forgive me. I'm getting over another lung infection and cold here. I'm moving and I can't freaking wait. I've never been more sick in my life than where I live currently. It is horrific and I am done. So I have 61 days. Right? Let me see. All of it. No, 70 days. I got like 70 some days. So, and I'll be bopping out of this place and moving to a new place in Alabama. So, anyway, the defendants next argue that testimony of Director Ezell should not be compelled because to do so would inappropriately intrude upon the workings of a coordinate branch of government and pose an avoidable and unnecessary separation of powers concern. What they're trying to state is that, look, we have a separations of powers in the Constitution. Article 3 courts, they are all Article 3 courts. There are some that get jurisdiction via Article 1, which is Congress, okay? But the Judiciary Act of 1789 is what still governs it and has everything set up. So those are supposed to be, even under Marbury v. Madison, which set out that we define the law of the land. Okay, yeah, that's fine, but there's public policy. You don't have any the court has never exercised jurisdiction over public policy. It just don't. Getting involved in Congress, like, I don't know, they're kicking a member out. They're not going to do it. Traditionally, it's not going to do it. That's the domain of that branch of government. And so long as they don't overstep it, for instance, if you do, if Congress does overstep it, the correct path is to challenge it in court. They don't stop and do a TRO to stop Congress. That's not how that works. All right. So they're arguing a separation of powers concern. The problem here is that directing actor Ezell submitted a sworn declaration in support of defendant's position, but now refuses to appear to be cross-examined. I think I get where the court's going to go with this. This guy's going to have to appear. They're trying to literally say, I don't care if you're a separate co-equal branch. I don't give a shit if you are the president's appointee. You will appear because I am a judge. I am a federal judge, and we are having this hearing, and you will appear, regardless of the fact that he's entered a sworn statement. He has to, we need to have this done. They want it done. They are purposely this is a play. That's why the government has pled up here, oppose avoidable and unnecessary separation of powers concern. This is one of them. Okay, so he says he now refuses to be cross-examined or deposed. A deposition. Well, it's the president. That's not how this works. It's just not how this works. I might be able to depose a manager or somebody if I can sue under like a Federal Tort Claims Act or some other legislative matter where I can bring suit on the government other than a personal suit of a government employee. If I sue them personally, it's kind of a backdoor around that. But I can't sue the government unless they acquiesce to do so. Same thing with the state governments, unless it's under civil rights. Is it 42 or 43 USC 1983? I think it's 42. Anyway, it doesn't matter. Civil rights statute that applies under color of law to the states. So they're wanting to depose the guy, and I don't think they have the authority to do it. They just don't. I don't think they have the ability to even compel his presence at all. Government's counsel embraced that very idea during the TRO hearing. The court's order that he appear or be deposed will not be vacated, meaning we don't care. Suffer. All right, Bish, you can just deal with it, Mr. Secretary or Director. You can deal with it. Come on. We're going to make you come. I'm going to send the marshals to come get you. Good luck. That'll be interesting. That'll be an awesome freaking news story. Holy crap, that would be killer. I beg them. I beg this judge to do it. I beg it. See how big of balls he has. See if he's got the one. Whoosh, whoosh, whoosh. They just swing and drag the ground as he walks. I highly doubt it. I doubt he has some beach balls. I highly doubt it. Nor will the hearing on March 13th, will not be vacated, nor will we postpone the 13th hearing. So they must have had it. If Ezell, I love how they said it instead of director, totally just cutting his feet off, making him not as important, does not appear in violation of that order. Now here the court's going to say, I guarantee you they're going to say, well, we're going to do something, but we can't really arrest you for contempt. I guarantee the court will have to decide the sanction, including whether or not to strike or limit his sworn declaration. Ba-bing, ba-boom. I told you, they know the judge is trying to he's overstepping, but he knows he can only go so far. He can't hold him in contempt. That's not going to fly. No one's going to go get him. That's not going to happen either. Because as soon as he orders it, the president is just going to issue an order in the DOJ and say to the marshals, no. That's all they got. They ain't got nobody else. FBI doesn't do that. That would be an order enforcing a court order. It'd be served by the U.S. Marshals. They have the most broad jurisdiction in the federal government as far as law enforcement authority. However, with respect to those other government employees who have not submitted declaration, they need to be produced These are the government employees that could be those that are terminated or even those that they're wanting to have testify. Most of this is going to be basically the plaintiffs who have not submitted declarations. They need not be produced, meaning he could have wrote it better. They don't have to show up. They don't have to show up, folks. They can skip the hearing. We're just going to force the president's men to come in. We will address the necessity, if any, of their testimony in due course. I'm sure you will. Plaintiffs remain free to bring all witnesses who appear voluntarily, meaning I'm not going to make you do nothing. But the government, you're going to suffer. Bitches, you're going to suffer. You're going to come. We're going to make you come. Counsel shall advise the court whether they intend to produce any live witnesses by March 11th at 5 p.m. If the answer is no to all counts, then the hearing will be moved to 1. This I get. The court's they got other shit to do. They don't have time to just block out an entire day, which this is an important issue. They probably should. Just my thought. I think they probably should. If the answer is yes, and live testimony will be heard, then otherwise it'll be on the pleadings and affidavits alone. If it's heard, then the hearing will take place as scheduled at 8 a.m. and a criminal trial will be interrupted. So say it is a docketing issue. This is fine. So they will do it at 8, and then we'll say, let's say the criminal trial was to start at 8. He'll just issue an order delaying it till probably noon or so. And then they'll handle this and then have to go back to the criminal trial. It's kind of a big deal. So otherwise, they're trying to kind of cram it in at a long lunch. And my guess is he'll jump it, probably do lunch at 12:30 for the criminal trial and come back. They'll recess and come back around 3, something like that. Which really, they may even try to just recess for the rest of the day at that point. So there's nothing wrong with that. That's normal. It is so ordered. March 10th, 2025. This asshat, William Alsup. That's I think he's an Obama. He's a Democrat appointee. I know that. I just can't remember if it's Obama or Clinton, but it's it's one of them. Yeah, he's an old dude. So that's it on that. So they're going to have something going on in California, even though the same thing's about to be done in another one. I think it's California. Yeah, Northern District, California. Yeah. Right here. Yeah, you highlighted. Yep, right there, California. All right, so let's go to this one here. And I'm not looking. I'm sorry if anybody's in chat. I'm not looking at it yet because I'm still focused on this. I will jump back to it in a minute just to check, just to take any questions. I think I got it. Now I can close that. Yeah, I don't know if I want to leave site. Yeah, we'll just wait. Yeah, here we go. All right. This one, I said I didn't read it. I kind of breezed through it. Like I literally like this. Oh, okay. So there's some here. So I really don't know the substance of it. I'm not going to do a 52-page read. I'm just not going to do it. I don't have time. You don't have time. We're just going to figure the highlights out. We're going to do a what I call a law school read, a cram session read, where you literally look for. In law school, we used something that was called IRAC, not the country, IRAC, issue, rule, analysis, conclusion. So I'm looking for the issue and the ruling, or the issue and the rule. We can kind of skip the analysis. I think we kind of know what the hell it's going to be. It's going to be, you're coming to court. We don't care. So, and I'm going to do this injunction. And ain't a thing you going to do about it, Mr. President. Well, there is things he could do. Congress could act. There's enough now to act. They could repeal tomorrow the Judiciary Act of 1789. You know what happens? The courts cease, except for the Supreme Court. Technically, they could obliterate the entire court except for one, the Chief Justice. That's all the Constitution. Go back and read Article 3. That's all it creates. It creates a Supreme Court and the Chief Justice. That's it. That's all there is. So that's why they did the Judiciary Act. Congress could do that tomorrow and then reconstitute it and say, hey, yeah, I like Alito and Thomas, getting older guys, and The rest, not so satisfied. We're going to do whatever again and let Trump get 8 appointees. That's it. Technically, I guess they could abolish. Well, they can't abolish it completely. The Chief Justice would stay because you can't. It's constitutionally there. But they could go in tomorrow and kill it and have the Senate pass it, President sign it, and it's done. The Judiciary Act of 1789 would be done. Every federal courthouse would close. Yeah, it's going to be screwed up, but you could bust it out in another 24 hours to have another one set up to where new judges have to be appointed. Yes, it will take time. No, it will not matter to us. Some cases will be on hold. That's just life. It's like a government shutdown. Have you ever noticed one? I haven't. Things still happen. So that's my viewpoint on it. That's just how I feel. It should be abolished and rebuilt. Period. Full stop. I'm done. I am done with this judicial activism. Lawyers suck. We suck. We are a bad group of people. There are good in every group. Absolutely. But these judges, even on state levels, man, their heads are like the size of damn, watermelons with ego. They don't care. Don't care. And even when the defendant should get the benefit of the doubt, and it's the law, they still won't do it. They still won't apply rules of lenity. They won't do it. It's just a bias that they seem to get. Even the ones that come in as defense attorneys, Jesus, man, they're just as bad. This is what all right. I'm getting in here here we go. Here's the title page. So this is going to be the state of Maryland et al. Or et al. It means and others. So there's going to be, I'm sure there was one that preceded this that had them all listed. There's like 13 states, I think. It's like all Democrat states, attorneys general. That's all they are. B, the U.S. Department of Agriculture. If you remember, there was the one for the, I shouldn't joke about it, but it is kind of funny, but it's the AIDS Foundation sued because they wanted their money from USAID. They wanted their money for their vaccines, AIDS Vaccine Foundation. They haven't done a damn thing ever. We should have had a vaccine by now. How many years? 40 years they've been working on a vaccine. They ain't going to get one. That was the last one, or the first big one that hit where, well, you got to release the money to these people. And the judge, well, you got to do all $2 billion. And then he got appealed up. Kicked back down. Well, he had to back off a little bit. He finally had to back off and throttle back. But the guy needs to be impeached. Every one of these judges. This guy too. This asshat in Maryland. So we've got the title page. Here's the memorandum. Federal court's a little different. In Alabama, and I not all. Well, I've practiced in 3 states. Alabama's kind of unique in that is that they've abolished common law type pleadings. You don't, unless you're doing an appellate, you don't have to do a memorandum of law. You don't have to do a freaking table of contents. This is all federal rule, local bullshit. I don't even think the federal courts in Alabama require, they mirror the state bar rules. But I could be wrong. I don't practice in federal court. It sucks. It's too tricky. You screw the pooch in anything, even like font, especially with the Supreme Court and the margins, and they could boot it. That's just what they do. So here's your table of contents of what they're going to go over. It's all about a TRO. Summary. When the federal government, get my highlighter, damn it. When the federal government terminates large numbers of employees still on probation because they were recently hired or promoted, it must follow certain rules. Yes, and the president has authority to do certain things. These are dealing with probationary people, okay? There are rules set up so that OPM has to, and the branches have to deal with them in a certain manner. They might have rules of, I don't know, you screw up once in 30 days, you get a write-up, but you're not fired or whatever. And then, when you're promoted, there's rules. But the president can abrogate those. He can abrogate them. There are some little hiccups or whatnot. That's, if you've noticed, that's why he hasn't fired, like, I don't know, just took and went, here's a list of the entire federal workforce and just drew a red line down and went 50-50. This side, they're fired. Keep this side. That he can't do. All right. So some of these rules are intended to help states manage the consequences of sudden mass layoffs. That makes no sense, but whatever. Workers who unexpectedly lose their jobs often need immediate assistance. That's not the government's problem. That is not the government's problem. The state can give them welfare if they want. And applying for unemployment, that's a state issue. It's not a federal issue. It's state. And searching for new jobs, obtaining social services, none of this is constitutionally protected, even though the courts have said, well, once you start handing the entitlements out, you got to keep giving them. They have rights. It's bad law, and it needs to be redecided. Nobody has a right under the Constitution to get free shit. I want my Coca-Cola, my EBT. Sorry, somebody texted me. A client did. They want they want to use their EBT at the gas station or trade it so they can. Hey man, I'll buy you $20 of stuff if you just give me 10 in cash, so I can buy a pack of cigarettes. This happens all the time. It's all the time. It's happened to me going into a gas station. It's out of control. Congress and the government itself recognize when they crafted the rules, states advance notice, or they need to give notice of big layoffs. Without advance notice, plan, organize, and reprogram many resources states are harmed. So these states are claiming that if we don't do this, we're going to be harmed. So let me back up. There is one court that has what's called original jurisdiction in Article 3 of the Constitution. It's the Supreme Court, and that's for states. State filing against state suing the feds. They can sue each other. That's not an issue. That's not a problem. But they know that if they go straight to these 13 states go straight to the Supreme Court, they're not going to get anything. It's going to get denied. Or if they get a hearing, expedited hearing, they're going to lose. They're going to lose. So what do? They forum shop. And you're not supposed to forum shop. The federal courts frown on it. Well, here, they don't care. They allow it because they're filing in Maryland. That is a liberal. It wasn't always that way, but because of the size of D.C. becoming so large and spread out, they're a liberal, Democrat-controlled area. They know that the judge is. They know what they can get. They're not going to go to I don't know. Let me think. The Eastern District of Tennessee, Chattanooga Division, or Knoxville. They're not going to get anything. They're going to get denied. In this case, the government conducted mass layoffs, but it gave no notice. Oof. I don't know what happened with that. Let's fix that. Ooh, come on, get out of the way. Gave no notice. Why is it doing that? They don't have to give notice. It's not a requirement to the state. So they're trying to say that the states have standing, A, because they're states, B, because they're going to suffer a horrific event if this continues and they need relief. They're going to probably claim that it'll burden their system and destroy it. Oh, God, you can't let them be fired because they're all going to want unemployment. Well, guess who gives them the unemployment money? The feds. It's not all state. It's just feds. Claims weren't required, or it claims it wasn't required to the federal government because it dismissed each one of these thousands of probationary employees for performance or other individualized reasons, meaning they did it for cause. On the record before this court, this isn't true. Bullshit. They were individualized assessments of employees. Same goddamn thing. I have to assess you. You suck. You're fired. Very simple. They were all, there were no individualized assessments. I apologize. I still don't see the problem. They were all just fired collectively. That's what they don't want. That's what their argument is going to hinge on, is that the president, even if he does have said power, he's used it inappropriately, is that it's not been done on an individualized basis. Look, man, there's several million damn people in the federal government workforce. You know how long that's going to take? You're not going to get it done. Accordingly, in the language of relevant laws, these big government layoffs were reduction in force, RIF, Because they had to be preceded by notice to the states that would be impacted. I don't know why it keeps doing this. Come on, go away. Come on. Thank you. I'm about to reboot the damn browser. Lacking the notice to which they were entitled, the states weren't even ready for the impact. They don't have to be. The president doesn't have to give that notice. This is absurd. Mind you, 13 states are trying, and these two judges are dictating literally the entire government. And I haven't even gotten to the ones that are, I'm going to have to find it and do it tomorrow, that are telling the president, oh, yeah, those guys you sent to Venezuela that are criminals, yeah, you got to bring them back. No. That's all he's going to say. No, not doing it. They're already there. That's if Venezuela, even, which they're going to kick them out because they're criminals. That's what they're doing. Let's see. The states are still scrambling to catch up. They remain impaired in their capacities to meet their legal obligations to their citizens. Because the federal government's recent discharge of thousands of probationary employees was not executed in compliance with the rules intended to ensure that states are ready. See, they're biased in this. It's not the rules for the employee. It's the rules for the damn states. That's not what the rules are for. To bear the load cast upon them when mass layoffs occur, and because the plaintiff states are not yet in so fact prepared, and because of these violations, recent directives of various, damn it, why does it keep doing this? God, it's annoying. The recent directives of various federal agencies terminating employees must be stayed. That's their argument. I knew that was what they were going to do. The states are being harmed. They just can't afford it. And because you didn't follow A, B, and C, it's not for each. Remember, if it was the way it should be, is that each employee could go, wait a minute, you can't fire me. No. There's a procedure. I get to bring it to court. That's a lot of employees. That's a lot of cases. This is a much easier way to do it, and to say the states use their power and say, hey, we're going to be hurt because of this. We're going to be hurt. And he didn't do it the right way, the way we think. Well, they're trying to exercise for the employees this clusterfuck of a decision, and it's not going to work out well. It's going to cripple the federal government, which is what they are. They're federalist, not in the traditional sense of the term, but they are absolute federalist, and yet they're taking a state. Any other time the states come to the court, they don't care. They just don't care. When it benefits them and they want their political opinions put forth and stomped into your neck, buddy, they're going to use it. Employees are purportedly terminated under RIFs or returned to government employee. They resume the status they joined before the government acted. In other words, they got to rehire them. They got to go back to the OPM. This is not an easy thing. It's not like they just go back to work the next day. They got to go back through the whole gamut. This judge is so stupid. He doesn't even realize that the same rules he's claiming were broke, he's kind of doing it too. That's a problem. 19 states and the District of Columbia, go figure, have filed suit against 41 defendants, agency secretaries, blah, mother freaking son of a bitch, this thing. Quit. You know what? Yeah, just let me, I'm just going to use the damn pen. Freaking A. Other federal agencies in their heads, the government, see electronic filing number 1. The states challenged the government's termination of probationary. Oh, well, that didn't work, did it? I am using Microsoft Edge because they have this little PDF thing, and Chrome is too sucky to have adopted that yet because, it's Chrome. The states challenged the government's termination of probationary federal employees. Plaintiffs have filed a motion for temporary TRO. The parties have filed briefing and evidence in relation to the motion. The court held a hearing on the motion on March 12th. TRO will be granted. Background. Now he's given his reasoning. I wish I had a ruling from a court in Alabama and you would see the complete difference. This is so much more in depth than it needs to be. Requirements for terminating probationary employees. In the federal civil service, blah, 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 blah. They're going to give a fucking history of it. The civil service, most employees are considered to be under probationary. No, they all are, unless they're appointed. Literally. And even then, they serve, the appointed ones serve at the pleasure of the president. That's it. In the first year or two of employment, probationary employee may be terminated because the work, performance, or conduct during this period fails to demonstrate fitness for qualification or continued employment for reasons based in whole or part on conditions before his appointment. If a probationary employee is terminated because his performance or conduct fails to demonstrate that he is fit for continued employment, the agency shall terminate his services by notifying him in writing. They were, all of them. Might have been the same piece of paper, but they were. Why he's being separated and the effective date. That was done too. The information and notice as to why the employee is being terminated shall, as a minimum, consist of the agency's conclusions. That was also done. And adequacies of his performance or conduct. That one I'm not so sure. I really don't know. I haven't seen it. Or I've seen it, but I haven't looked at it in depth to see if that is missing. And I'm not sure that it should fail because of that. Otherwise, probation employee may be terminated as a part of a reduction in force. The parties have not identified any other method by which probationary employees may be terminated. With respect to RIF, statutes and regulations set forth, blah, blah, blah. The relevant regulation provide each agency shall. The fuck does it keep doing this? Releases a competing employee from his or her competitive level by separation when the release is required because of lack of work, shortage of funds, blah, blah, blah. We can just keep going down. Position dies. I see. I'm looking here. It's a little grammar correction. I guess the statute has an issue with the grammar. Instead of saying dies, it says die. So the SIC means spelling incorrect. To erosion of duties when such action will take effect after an agency has formally announced a reduction in force in an employee's competitive area and when the reduction in force will take effect within 180 days. This is the Code of Federal Registry. That's what they're citing. When conducting RIF, an agency must follow certain retention preferences as laid out in the state or in the statute and regulation. Directing the Office of Personnel Management to prescribe regulation for the release of competing employees and a reduction in force would give due effect to their tenure of employment, military preference, length of their service, and efficiency of performance ratings. Providing that competing employees, remember, this is for an individual basis. What they're arguing individual basis, but it's so that managers can't just make shit up. That's what it's for. It still doesn't address whether the president has the authority. Because that's their boss. He's the one. Employees should be classified on a retention register on the basis of their tenure of employment, blah, 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 blah. We'll just skip on here. An agency must establish competitive areas which employees compete for retention, designate the competitive areas. They're really getting into the minutiae here to make this work. At least 90 days before the reduction in force. So they know they can't get them on the first one. So they're using this reduction in force argument saying, hey, you're trying to do this wholly and not correctly. You're trying to do it for the whole employment staff of the government or large sectors. This is really a RIF. You're not really doing what you're supposed to do. So we're going to stop you. And instead of each person bringing a suit, they're allowing the states to do it based upon their suffering. Positions include in the RIFs that would permit the agency to reassign and retain employees without causing undue interruption, rank employees for retention based on factors including the tenure group, time in service, whatever. Let's go skip on. The notice must be provided A, to the employee. I don't know why my eyes are bothering me. I need my glasses. Oh, hey, look at here. This never happens. Sweet. The employee's collective bargaining representative, and if RIF involves at least 40 or 50 employees from the competitive area of the state in which the employee's duty station was located. Doesn't even talk about it, but notice to the state. That don't matter. Period. And a lot of the states, depending on your state, you may not be able to get unemployment if you're a government employee that's been canned, eh, or especially under probation, they may not cover you. You may not get it. They may have a carve out because some states are, if you can get it if it's not for cause, like for instance, it's not pursuant to what the president's trying to do. You didn't do anything. Some states may allow this for them to get unemployment. Again, the feds are paying it. Some states don't. You get fired by the feds, or it's anything but a layoff, you don't get unemployment. They just don't care. I don't think it's right. You should be able to get it just as equally as anyone else. But if you're fired by the feds, they don't care. They're not going to give it to you. I'm sure most of the northern and western states probably do give it. Most of your southern states are not going to. That notice must include a number of employees separated from the agency by reduction in force, effective date, any other information by OPM. Remember, it's OPM, not the president. It is the president, but they're using OPM, including information needs identified in consultation between OPM and the Department of Labor to facilitate delivery and placement of services. When an agency fails to provide the requisite notice to the state, the employee may not be released due to a reduction in force. The states, and the question too comes is, even if they're going to argue this and they say, okay, look, you didn't follow the procedures, do the states have the standing to come in for the employee? That's what they're doing. They're not suing on behalf or with 100,000 employees. They're not doing that. They're doing it on behalf of the state, saying, hey, this is going to burden us in our unemployment programs, and we just can't handle that. And you're not doing it correctly, so therefore we're going to assert their rights. So the state of Minnesota wants to assert a right of a fired employee or terminated in Georgia. There's no standing for that, even for a state. There's nothing there. You can't assert another person's right that's not within your own damn border. Now, if they wanted to do their own, that's another argument. The states, in turn, are required to carry out rapid response activities pursuant to workforce, some other dumbass law that they make the states follow, must be delivered when an announcement or notification of mass layoff is defined. Mass layoff as the one that meets the state's definition of a mass layoff, as long as the definition does not exceed a minimum threshold of 50 affected workers. So I guess they're saying if it's 49 or less, this doesn't apply. Or where a state does not define a minimum threshold for mass layoffs, meeting the requirements of the paragraph of this section, layoffs affecting 50 or more workers. Rapid response activity is defined as the activities provided by the state in response to a mass layoff. Provision of information on and access to available employment and training activities, provision of emergency assistance and assistance to local community. And look, this Workforce Act was 2014. We know who was in control then. I think Democrats had full control at that time. These guys just want to protect their state, their own little private fiefdom. That's all they care about. They don't give a shit about these employees. They don't care. They don't care. These rapid response services are designed to cushion the blow of a sudden mass employment. See, the court's trying to see. They're not addressing the standing issue. And honestly, I'm not sure if the feds did either. But, the standing issue, that would be my argument is, look, they don't have standing, Judge. If they want to file the Supreme Court for their own issues, that's fine. But really, they're trying to use this as a back workaround for a individual to assert their right, provided, again, and I'm not familiar with it or not, whether or not they can actually bring an action against the feds or that agency for a wrongful termination. I don't know. Usually they have a administrative procedure to follow. But we're talking, again, the president, the chief executive. There is no one higher in that. This is life. It's kind of like the CEO just going, I'm laying everybody off. Yeah, they've got laws to protect people, but it doesn't mean that the federal government or the not the feds, but the president doesn't have authority. Let's scroll down here. The government's alleged actions. Yeah. February 11th, Trump issued executive order. I have no idea. It's like a my left foot signature. Freaking idiot. God, I hate these apps. Implementing the president's Department of Government. And by the way, if you're offended easily, just cut off. You're not going to like it, because I am not. I am as blunt as Richard Pryor. I'm just telling you. Here we go. Doge. I knew that was going to come up. Set out by its purpose. And remember, here's the funny part. And they're not going to bring it up. The Doge is a renaming. They already existed. Doge existed. It was for, at the time, they just kind of redirected what their efficiency would be looking at, but it was for computers, to my knowledge. Basically, under Obama, I mean, this is his baby. They just took it and went, yeah, okay, yeah, it's already been approved. Yeah, we'll just repurpose. That's it. Instead of computers worry about that, yeah, we're just going to worry about, do we need these people? What can we cut? What fat can we cut? Oh, $200 billion to a foreign country to try to overthrow their government? No, canceled. That's what they're doing. That is Doge in a very short or small nutshell. Actually, a large one. It set out its purpose by eliminating waste, bloat, industry. We all know what they did. February 11th and 12th, various agencies terminated large numbers of probationary employees. Remember, once you're past probation, you do have certain rights under statutes that they have to then start doing, like a show for a cause. They have to, dang it, they have to terminate you for cause. The states allege, hell, my chair won't function. This is what happens when you do it on the cheap. They're just streaming. Everybody else got these nice microphones and chairs. Here I am with a $50 microphone, a $30 headphone set, and an old chair. Yeah, whatever. Just suffer. And in a February 14th email, plaintiffs alleged, again, they got notice. It's just by email. But they got notice individually, guys. That's one key. The feds are going to rely on that. Plaintiffs alleged that OPM explained to agencies, we have asked you to separate probationary employees you have not identified as mission critical no later than Monday, 2/27. We have attached a template letter. The separation date should be as soon as possible, as consistent with applicable agency policies. This is followed by several more agencies terminating blah, blah. Go on. I hate to keep saying blah, 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 but this is literally blasé crap. The state's alleged harms. Again, we're not talking about individual harms. It's and to a degree, I get the states saying, "Hey, look, we can't come in there for them. We got to do it for us. This is going to hurt us financially." Problem is, they don't have standing to assert someone else's right, unless maybe depending on the statute, to assert it in their state. Like I said, this has never been done. Okay, Minnesota cannot do it for a Georgian. It's just not how this works. You know, they don't have jurisdiction. They don't have squat over a Georgia citizen. Anything that they try to, even an extradition for criminal charge, it's got to be done with an extradition warrant. They have to have the cooperation of the other state. They have to. Let me see here. Okay, good. No one's in chat. Good, because otherwise I've gone almost an hour and not looked. Where am I at? Yeah, here we go. The states alleged several injuries resulted from the government's failure to follow RIF. These situate these industries into 5. 1, harms to the states. Back to the states. A harm to the state, which both federal and state law require the states to develop. Harms to the state's administration of unemployment benefits. I have no idea why this thing is this retarded. This is horrible. I have no idea. I'm about to just quit doing it. Unemployment benefits. Harms to this. It's just harms to the states, not people. They don't give a shit about the employees. It's just the state. on embedded workers, harms to the state's finances, harms to the state, harms to the state, harms to the state. Is there something wrong with my mouse? I mean, this is getting annoying. There we go. There. Let's scroll down. Because of these increases in claims, the states say they're experiencing administrative burdens and costs. Okay, so we get the idea. It's going to be state burden. The state's hurt. So we're going to say, you didn't follow the rule. We want you to stop this because we just can't handle it, even though they're not the ones fronting all the money. And we'll go here as proof. States offer the following numbers, among others, so it's not all of them. Maryland claims 813 former federal employees in the last few weeks. Let's see, California, 1,600. I mean, we're not talking 30, 50,000 people, guys. This is not what we're talking about. It's just not. These are not that as many as they claim or as the news media is putting out. Because of these increasing claims, states say they are experiencing administrative burdens and costs. Okay, well, let's see what the feds say here, the defendant. I bet you we have to go all the way through it just to get to their little blurb about it. Reviewability. Finally getting to that. The court first examines whether it may review the actions at issue. It concludes, it's done. They've made the decision, or it's made the decision, that the states, or at least a subset of them, a subset, there's no subset of states. Like, it's the state. There's no substate of the state of Georgia, except for counties. That counties haven't sued, have standing. That they were, that they were reviewable final agency actions, and that Thunder Basin does not preclude review. I told you, that's exactly what they were going to do. They're trying to say the states are the ones of the harm and they have standing. But really and truly, they're just asserting someone else's right. Not cool, man. If it has to do with something like an election, a civil rights issue, and you have a group of people being denied rights, the state can then do that. You're just not going to see it. And they don't do it for individuals. I mean, whether or not they can, maybe so, maybe not, but they don't. The states tend to only do anything when it affects the state itself, not the people, the state, the actual government, and the rights of the government. That's what the Constitution really protects and outlines. Justiciability, meaning the ability for the court to litigate it. Article 3 of the Constitution limits the power or judicial power of the courts to cases of controversies. Article 3, Section 2, Clause 1. The law has long understood this language to limit the judiciary to settling genuine live disputes. It's got to be when you do most people have heard the term "don't make it a federal case." Hey man, don't make this a federal case, man. Damn. There's a reason behind that. Along with personal jurisdiction, or at least in rem jurisdiction, a federal court's got to have subject matter jurisdiction, got to have diversity of citizenship, meaning, let's stick with that. Diversity of citizenship, a person from Georgia and one from Mississippi. You can't have two Georgians. You got to have controversy in excess of 75,000, and over $25 you get a jury trial. All right, that gets you in for like even a state issue, matter of law, and you're suing someone, in another state. Okay, fine. Then you have actual federal issues or federal questions that will beat diversity. A Georgia could sue a Georgian. That's not a problem. If it's under, like, for instance, a company doing something wrong with their hiring or firing or discrimination, etc., then yeah, under Title VII, you could do, you can sue the actual state. That's doable. Otherwise, with the federal court or federal government, only if the falls under what's called the FTCA, the Federal Tort Claims Act. I had to think about that one. That outlines basically what we will allow you to do. Okay. All right. So let's continue. Between adverse parties, thereby preventing the federal courts from issuing advisory opinions. When a dispute does not fit that description, it is considered non-justiciable. And the federal courts lack, again, we just talked about it, subject matter jurisdiction to decide it. An essential and unchanging part of the case or controversy limitation is requirement of standing. You got to always have standing. So along with that, you got to have standing, and the standing is what gets you in the door, and that is what we've already discussed. The standing inquiry is often cast as asking whether the plaintiff is a proper party to bring the suit. It's already been. They're not the proper party. It's the people that are fired, the ones that are actually affected by the decision. I get it. If those people want it, yeah, sure. And they're able to do it. Yeah, it may clog, I don't know, 20,000 layoffs or whatever. Yeah, that's going to suck for the federal courts if everybody brought a suit. Oh, well, suffer. I mean, that's just, that's what your job is. By assuming or ensuring, among other things, the plaintiffs seek relief from only those acts that affect them in a definite and distinct way, the standing doctrine ensures that the federal courts, God damn it, keeps doing that. Courts only decide only the rights of individuals. God, here you go back. Oh my God, they're going back to Marbury v. Madison. I may do a video on that. That is like the first big case, really the first one you learn in law school and civil procedure, because it sets out the supremacy clause, essentially. And it's not even about that. That's the hilarious part about it. It's not even about that. Let's see, they're quoting it here. It's an 1803 case. Therefore, exercise only their proper function in limited and separated government. Such scrutiny is necessary to filter the afflicted from the abstractly distressed. That would be the state at this point. The abstractly distressed, that's the freaking state. That ain't the person. Persons ain't, they're not the ones alleging anything. They've done nothing. Even if it was their union, like the other one, yeah, okay. Yeah, they got standing. Yeah, okay, fine. Let's hear it. I don't agree with them doing the order, but, let's get them in the front door. They can hopefully assert a good prosecution for their case. To establish standing, a plaintiff must show concrete, particularized, or actual imminent injury. Again, state's not suffering any of that. The injury was likely caused by the defendant, and the injury would likely be redressed by judicial. I'm having a hard time tonight. Judicial relief. If the plaintiff does not claim to have suffered an injury that the defendant caused and the court can remedy, there is no case or controversy for the federal court to resolve. That's usually a 12B6 motion to dismiss, meaning there's failure to state a claim for which relief can be granted. The court has to be able to do that. Here, the states have demonstrated the fundamental elements of standing. They are entitled to invoke their federal jurisdiction over their claims, and they address each element in turn. They are saying they have injury, which we've already gone. No, I don't think. No, it hadn't even happened. No, I don't think so. Which is why they're wanting a TRO and not just a complete judgment. Let's see. Jesus, where's number 2? Causation. It's plain to see at least some of the harms the states have experienced, namely increase of cost of administering welfare as a direct and foreseeable result of the agency's failure to provide RIF notices. Accordingly, on that basis alone, the court is confident that no causation defect would wholly defeat the state's standing. Wrong. As the harms based on the expected increase in public benefits awards and future lost tax revenue, the government argued during the TRO hearing that these harms were self-inflicted. The court disagrees. Costs that states incur in the satisfaction of mandatory legal duty, even when arising under state law, is not inflicted on theirself. And here legal duties arise both under federal and state law. Causation is also not defeated by certain theories' reliance on the anticipated behavior of third parties. This element is satisfied when a third party will likely act in predictable ways in the conduct at issue. For much the same reason states appeal to future increased benefit payout was actual or imminent injury of that harm is traceable to government's termination, meaning the government has done something and we're going to suffer a harm, therefore we have standing. That a lot of people would love to be able to assert that, and it doesn't work. That is textbook predictability. Sure it is. Redressability. Finally, states have shown their harms to be can be redressable by relief sought. For a TRO to issue, the court has to find that they would most likely be victorious. The plaintiff would be most likely victorious on the matter at hand in court. If the court can't say that, then they don't get the TRO. Let me go further down. Let's go to jurisdiction. The states challenged two distinct federal actions. First, OPM directives that allegedly directed other federal agencies to dismiss probation employees en masse. And second, the actual agency level dismissal without notice. But the nub of this lawsuit is the lack of notice the states received. It's the employees, you retard. The employees are supposed to get the notice, not the freaking state. This is stupid. This makes literally no sense. My guess is where the Supreme Court's going to come in and go, no. I know that's where Thomas and Alito is going to argue. So we know that's what they're arguing under. It's purely about how, it's going to hurt our ability to pay welfare out. Therefore, we should be able to get an injunction to stop this. Okay. It's a person's right. You're asserting that's not even necessarily in your jurisdiction. So maybe it should only apply then. If I was the state or the feds, I would say, okay, judge, if you're going to issue it, it can only be for employees in those 13 states. That's it. The rest of them doesn't apply. They have to, the employees need to do something, or another court needs to figure that out, not you. No, they want to do a nationwide one. And I don't think they're going to meet the burden. I just don't. It's not common that you'll get a nationwide. Even when the ATF was trying to ban braces for pistols, they were wanting the people suing, Gun Owners of America, et cetera, were wanting a nationwide ban because, look, the ATF's going to go nationwide and start taking these and charging people with felonies. But instead, the court initially said, okay, only for this circuit, which I think it was at a Fifth Circuit. And that's all it protected. Eventually, we got a nationwide one. That's the only reason they weren't busting down my door and your door to steal and prosecute us for 10 years in prison for having a short-barreled rifle, as they claim, even though it's been a legal device for a pistol for over 15 years. While the government refers to the acts at issue as alleged final agency actions, they're not necessarily yet. It does not otherwise dispute the dismissals or agency actions within the meaning of the APA, Administrative Procedures Act, which is also where I believe, if I'm not mistaken, I think that's where the ATF ran afoul too, because they were changing rules on rules that changed laws that they didn't have authority over, and they violated the act. So that was where they attacked them and won, and rightfully so. The ATF does not have authority to just change Congress's interpretation of what they passed. They just don't. That's an executive branch function, and the executive branch doesn't get that option. If Congress wanted braces to apply, they would have said it, even though it's 1934. Change the law. As for finality, the action is final whenever two conditions are satisfied. The action is the consummation of the agency's decision-making process, and the agency is one by which rights or obligations have been determined from which legal consequences will flow. The firings without notice undeniably meet this standard. I don't know why it keeps. It was like a freaking heartbeat. Effects of self-evident legal consequences for both parties and plainly marks the end of the agency's decision making. We don't know yet. Trump could have rehired them back within 60 days. Who knows? 6 months. Don't know. He hasn't decided yet. This is just a start to figure out where is the fat. What do we not need? Don't know yet. We're just starting. So it's not final. Claim challenging. The government argues the court has no jurisdiction to hear the state's claims because of an alternative administrative review set up by Congress. Thunder Basin Coal Company. The Supreme Court articulated a two-step and now, what the hell is this doing? Trust me, this is annoying me as much as it is you. Articulated a two-step analytical framework to assess whether Congress impliedly divested the district courts of jurisdiction to hear challenges of an agency action. In other words, did Congress even give you, again, did they give you an Article 1 jurisdiction or not? Remember, they could go back and say, we take it back. You don't have a right to hear any goddamn thing. That's it. You're done. They could do it. They could have already done it. In fact, they should have done it. They should have been in concert with the president, and they weren't, or seemingly aren't. All right. First, the reviewing court asked whether some statute offer or either explicitly or implicitly channels certain claims. Where is my freaking Rumble things? Dang it. Let's do this. Live chat. Oh, hey Jefferson. Sorry, buddy. That's funny. Just some asshole lurking here. Yeah, I'm not. This new Rumble thing, I'm not real sure I like it or not. It's really set up like StreamYard, dude. I'm sorry I didn't see your post. I really am. Like I said, I'm just learning it. It seemingly is set up. I hope the stream is okay on both because honestly, I think StreamYard is like, I want to say it's like $8 a week for the app. This motherfucking thing is free. Now I do have Rumble Premium. You know, it's like I think I pay $10 a month for it. It's not bad. I was a member of Timcast, and when him and Crowder both, when they converted, you automatically got Rumble Premium, which allowed you to get this. So I'm hoping this works because it goes to a lot more. For some reason, StreamYard doesn't do a damn thing. Yeah, I am using it, Jefferson Post. I'm going to respond to see if I can even get a response here. Yep, I am. Oh, cool. Only Rumble Studio participants can see. Well, that's some bullshit. That's private. Oh, cool. You're on YouTube. That's neat. It shows a little logo of the YouTube logo. Yes. Tell me whether or not you can read that one. I can do all or I can do individuals. Cool. Yep. Gotta have grounds. Yep. Gotta have grounds. They ain't got none. Not even coffee grounds. Let's be like a landlord suing. Let's see. Can I do this on the screen? StreamYard's cool in that it allows you to actually go through the screen. Oh, I see it now on the actual app. I can see it now. That works. Great. Awesome. Thank you. Let me see. That'd be like a landlord suing a company because they fired his tenant. Yeah. Well, no, not even that, because you don't have a contract with the feds, man. You know, if you have a contract with a landlord, if it's month to month, yeah, you're out. if you're not, and you have a 1-year lease, you got to breach the contract. And then they've got to go and do an unlawful detainer and sue you and get your ass thrown out. Damn it. That's the rule. That's how the law works. So it's kind of like a right to work state. I mean, look, if I hire you, yeah, there's procedure acts, etc. But again, we're in uncharted territory here with the president, that he can do literally what he wants with the executive branch. There is nothing ahead of him or on top. Most of these, like when it comes to your state labor laws, I mean, you have state oversight. Don't see on YouTube since you wrote. Oh, that's great. That's great. So there is issues. I was wondering about that. Test. I don't see a test. Is it actually streaming video on YouTube, or is that dropped? Huh. That's weird. Okay, so Bama Law did it. That's my other account. That's peculiar. Let me see if I can do just this. This is cool to be able to do this. It's what I was wanting to do, is just test stream, just to see. Tell me what you can see on this. I'm testing or doing it directly to Rumble or to YouTube. All right, good. Cool. Now damn it. Yeah, Rumble. Test. That's what the hell? What is it doing? It's posting it under my actual Rumble account. That's weird on Rumble. Huh. It should be under Bama Law. I don't get it. Well, that sucks. Cool. Yeah, I see that too. I don't understand why. I mean, it's it's funny. Your name name for YouTube is what it is, because yeah, that's my last name. So that's my account name. I don't know why it's not coming up as Bama Law, but then it did above that. That's really weird. Thanks for joining me on this, so I can actually see what the hell's going on and actually figure out if this works. Because I would like to save that $30-something a month. That would be fantastic. Let me try all again. See what happens. Nope, still coming up as me. That's bizarre. Well, I'd fix that shit. That's some bullshit. I'll just try it. I'll just leave it as YouTube because I got one on Rumble. So are you on Rumble? Let me see if are you on Jefferson Post? Are you on Rumble? It looks like, no, you're on YouTube, aren't you? It's showing one on, well, now it's showing two on YouTube. This is cool. We get to test fuckery tonight, because this is what's happening. Test. I should have been a test on YouTube. It's coming up as Bama Law. I don't know what I'm going to do to fix the Rumble when it's popping up as my actual account name. That's weird. All right. Anyway, you can screw it. Let's go forward. First, after reviewing a reviewing court asked whether some statute either explicitly or implicitly channels certain claims about an agency action away from the courts and into an administrative agency. This inquiry involves examining the statute's text, structure, and purpose. Second, if the reviewing court determines that the statute does not channel certain claims away from the courts, it then considers whether specific claims at issue fall within that category. We're still they're stuck to this, the states being harmed shit, not the person. No, the California one actually was sued on behalf of the unions. Is it individual? You could argue it. Yeah, because under the collective bargaining agreements, they have the ability to do that. Yeah, Rumble's not too bad. It's seemingly working here. As both the state and the government observe, Congress has provided for the exclusive administrative review of most. Congress has provided. Okay, I see that argument coming. Most employment claims brought by the federal employees. It's probably under the Federal Tort Claims Act, I'm guessing. The first step in the two-step framework, 2 statutory review schemes are relevant. The first, oh, wow, I've never heard of this one. My daddy was a federal employee for 35 years, and some of this stuff must be new because shit, I ain't never heard of it. Federal Service Labor Management Labor Management Relations Statute in Title VII. I think that's also where the discrimination statutes come in under Title VII. As the District of D.C. recently explained in a similar context, FSLMers, we'll call it FSLMers, stupid, I get so sick of government acronyms. They suck. Nothing's worse than the military. Governs governs labor relations between the executive branch's employees. It grants federal employees the right to organize, here we go, bargain collectively, which again, if they had come to the damn court with the instead of the states with the damn union, they might have some standing. I don't see standing, period. And it requires that union and federal agencies negotiate in good faith. Okay. It's usually for people that are actual employees. Like I said, if you're, you could join the postal bullshit union as a probationary. It didn't do you any good at all. Like I said, you break a leg, fired. You don't, let's say your run is in 2.5 hours. That's what the postmaster says. And you're, I don't know, for a week, you're like 3.5 hours. You could be fired. They don't care. They do not care. And the union does zero. They can't even go on strike. What's the point of the union? They're a joke. Let me see if I can get this. I'm trying to get this to stay up where I can read these texts. And I'm just not able to. Well, nope. Every time I go to click over, gone. I don't know how Sean does it. I just don't know how he does it. He seems to be able to stay on top of the text chats coming in and not. All right, chat, go on. Further establish a scheme of administrative and judicial review. Under that scheme, FLRA, a 3-member agency charged with adjudicating federal labor disputes, reviews matters, including negotiability. They're getting into minutia of detail. We're still back to standing. They don't have standing, period. My guess is this goes to the Supreme Court. It won't go to, it will go to the appellate court for the District of D.C., but we know how that'll turn out. The Supreme Court's going to boot it on. I would be shocked if they didn't just boot it on standing. It's the easiest way. The Supreme Court is just like any federal court. The easiest way that they can boot a case to get it off the docket, they will do it. And usually that's a 12b-6. Motion failure to state a claim for which relief can be granted. There are other ones under 12b. I think there's 7 or 8 total. 12b-6 is usually the one. Other than standing, and jurisdiction and venue. And venue is not damaging too much because as long as the court has jurisdiction, you might have a venue issue of, they sued in Georgia and they should have sued in Alabama where the defendant is. It's not a big deal. They can just transfer a venue. Direct review of FLRA's decisions is available in the Court of Appeals. So what the fuck are we doing? They should have just sent this immediately to them. This is another problem I have with the courts. Everything has to be time consuming. I will get to that. You get in a criminal case and you have a bond or bond issue. You get denied a bond. And let's say by statute, I'll just make it up. Within 30 days, the court has to take it back up on to decide it again. Instead of just getting it over with, especially if you have a judge that's going to say no, they'll just set it out 30 days just to drag the shit out instead of the court going, I'll be here next Monday. We'll just get it done. Nothing is ever done at any speed that's reasonable for anyone. Normally, you come into court, and if anyone's ever been into court for traffic issues, they may set you off 90 days or more. It may be more. Most criminal cases, like in Alabama, I had people that between their prelim hearing which is in district court, we would waive to get it to the grand jury. Hell, it would take 3 to 5 damn years. So the whole time they're on bond for 3 to 5 years waiting to be indicted. And finally they get indicted. Finally they go to court 7 years in. I mean, I had guys that came in as, 17-year-old and literally went to prison with wife and kids because they were in their mid-20s. It's an absurdity. The second statutory review scheme is set out elsewhere in the CSRA, which separately established a comprehensive system for reviewing personnel action taken against federal employees. Okay, let's skip down here because this is going to be the same shit, just continual regurgitation. Let's see, here we go. Temporary restraining order. Okay, now we get to the logic. There's not really any logic. The logic is about that of a loose asshole. Yeah, all you hear is because there's nothing there. Having determined the court has jurisdiction to hear the case, the court turns to whether it can issue a TRO. Standard for temporary restraining order is same as a preliminary injunction. Those are similar. They differ based on time. So that's why they're wanting a TRO and something to be done, not just to stop the court or the government and say, hey, you can't do this. You can't sell this piece of property. You can't do, you can't build a home or whatever. That would be your preliminary injunction. That would be your prelim injunction rather than a restraining order. If you want, well, but this is an easier example. An employee that's being fired that hasn't been totally fired, you might run to the court and get a TRO, or some other issue with civil rights or whatever. You might go and get a TRO so that it's not only continuing, but that you can take action upon it. The party seeking a temporary restraining order must establish that he is likely to succeed on the merits, he is less likely to suffer irreparable harm in the absence of preliminary relief, and that the balance of equities tips in his favor, and that an injunction is in the public interest. Can anyone tell me how the hell that's supposed to be in the public interest? If anything, it's vice versa. This is ridiculous. This is not in the public's interest. The public's interest is to get rid of these damn people and to get rid of the bloat and to keep people from blowing the government debt out of control and overstepping all of its constitutional boundaries, and to reel in. Look, we shouldn't be able to go other countries, give $200 billion to Egypt so they have a freaking coup. That's not the point. Now you can argue, say, oh, well, the policy, the president's public policy, the Congress can do it, blah, blah, blah. Fine. That's not what we should be doing. And that's what the election was based on. And this is the result. They don't like it. Tough. That's what they tell the other side. If the roles were reversed, they would say tough. Suffer, bitches. They wouldn't care. They wouldn't care. They must make a clear showing they are likely to succeed at trial. Double talk and jive is what I've heard. I still haven't heard how they're going to succeed at trial. I still don't see how they have standing. It's an extraordinary remedy. It may only be awarded upon a clear showing the plaintiff is entitled. It doesn't take a lawyer to figure out that they haven't shown that. So, of course, the court says, they've done it, y'all. They've done it. Likelihood of merit success on the merits. Again, they have to do that. They have to show that. We don't have to look at it. Let's see. Agencies conducting the RIFs. We can skip that. Oh, good. We're 3/4 done. Sweet. Let's see what this one is. The states also provided affidavits from individuals. Again, they're not suing. They're just getting affidavits who worked at certain defendant agencies, reflecting determination decisions not based upon individualized assessments. The CMS, Chief Human Resources Officer, did not review the positions for suitability, never read a single person's resume, terminated probationary employees, and had no personal knowledge of individual performance. And then for the wonderful IRS, I bet most of these are IRS people. explaining the Treasury did not review or consider the actual job performances of these probationary employees. That's not hard. Again, that's really not hard. They could go back and do that and just refire everybody. Or he could just, reinstate them and then just fire them again and make them keep going to court and just keep continually doing it. They could play this game. The easiest way to do it is just to tell the government or the judges, go fuck yourself. Deuces. That's it. That's the easiest way to fix it. I don't know that Trump's going to do it. I'm afraid that he won't. I'm afraid he's going to keep running back to the courts and he's not going to get the relief he wants. It's never going to happen because you have two justices of the Supreme Court that are utter wussies and they freaking bend their knee every time, it seems. And Coney Barrett, damn Chief Justice. And I think the biggest problem comes is that I know I'm going to do a video on the American Bar Association. They're the issue. They're a damn criminal cabal that runs the damn law schools in every state, almost damn near every state, to prevent anyone who has not been an ABA grad from even taking the bar. Yes, there are non-ABA schools, and I don't mean the online schools in California. I don't care about those. I know right offhand, Tennessee and Alabama both have a school, and the state regulates it. But you're screwed. If you don't go to the ABA school, they have all of these guidelines set to where you can't go and just get a license somewhere else. Texas allows you to do that. So if you, for instance, with Nashville School of Law, non-ABA, and you got a Tennessee license, you can motion in and get a Texas license. That's not a problem. But very few states are doing it. They probably shouldn't even have the damn bar exam. It's a freaking joke. All it's there for is to prevent people from actually even practicing law. And you think, oh, well, that's good. We need to have that. It doesn't do what you think. It doesn't do what you think. It doesn't test your knowledge as to the law. That doesn't happen until you practice it. It's called practice for a reason. All right, back to this. Explaining the Treasury did not review or consider the actual job performance or conduct of any employee. I know that I normally don't see a court referring to them in first person, especially this way. I know this because this fact was the scope. Oh, okay. So he's quoting. Okay. I was going to say that didn't make sense. Openly in meetings. At the TRO hearing, the government was unable to supply the court with a number of probationary employees who to date have been terminated from relevant agencies. I don't think the government has to. And that's why they did it. The government offers no contrary evidence. The court does not render any conclusions regarding what precise language determination for cause must contain. However, the law is clear and dismiss an employee due to unsatisfactory performance must honestly be dissatisfied with the probationer's performance. Well, how do you know they're not dissatisfied? They all suck. It's the damn federal government. I'm sorry. That's not a hard conclusion. I'm done with this shit. I am so over it. Yeah, even as a lawyer, I am so over it. I go to work at a law firm. I come in the next day and they fire my ass. That's it. This has to end. If we don't do something, this is unsustainable. Full stop. And now we have courts dictating public policy. The affidavits filed by terminated probationary employees reflect that they received boilerplate notices. Well, suffer. Too bad. They got individual notice. Who gives a shit? Maybe they should have said, oh, dear Mr. Johnson. Oh, dear Mr. Bailey. They don't have to. It just says individual. They got it by email. That's enough. There's nothing else that the law requires. Further underscoring the court's conclusion that these terminations were not based on qualification or performance, that any notices to employees did not cursorily identify any issues with the individual's performance. We're back to this individual shit again. The states are still trying to go, yeah, it affects us. It affects us. It affects us. But we got to assert these people's rights because that's how it affects us. There's no standing. This should have ended on page 1. That's it. One order, one page order. The plaintiffs have no standing. The case is hereby dismissed without prejudice. That's it. It's easy. No, this guy has an agenda. So he writes a goddamn novel to force that on us. It's, I don't know what the income will be in this. I don't believe they'll ever repeal the Judiciary Act because I don't think Congress has the balls to do it. I just don't. I don't think Trump has the balls to become Andrew Jackson either. I just don't. Unfortunately, he's done a lot of good stuff. I just don't think he's got the balls to do it. I hope I'm wrong. I really hope I'm wrong. Here's one example for USA ID. I am terminating you on the basis of best interest of the U.S. government. Okay, well, you're probationary. Bye. Indicating this notice is to notify you. This notice is to notify you. What you say? This to notify you. Whatever. That's me being anal. Notify you of the decision to terminate your employment in order to promote efficiency of the federal service in accordance with the priorities of the administration. Okay. I mean, it's still, they followed the rules, I think. Even if they have not followed the rules, individuals must present their case with standing per the law, not the states. They don't have it. That would be like the state of Alabama trying to sue the federal government for the government to cease funds to Israel. And that state of Alabama, oh, you can't do that. That's wrong. It hurts us. We have contacts with that state. We have contacts with Israel. We do business with it. We have a defense contractor. You can't do that. They don't have standing. They just don't. I do not consider it in the general GSA again. GSA is, I can't remember if they're over OPM or vice versa. I believe they may be equal basis. I can't remember. But GSA, the General Services Administration, is similar to the OPM in that it covers everyone except the post office. Doesn't cover them at all. I do not consider it in the best interest of the government to retain you. This is the president talking in the federal service and have decided to terminate your employee during your probationary period. Another example, I regrettably inform you that I am removing you from your position with the agency in the federal civil service effective today. Remember, everyone also, if you're not in the post office, you're in the federal civil service. If you take an exam to get in, it's a civil service exam. Everybody does it. Boom, right there. Unless, like I said, they waive it or you're a direct appointment. Then, for instance, if I were to ever be hired as an assistant U.S. attorney, which apparently that's never going to happen. I've tried. Again, the ABA, good old ABA, because I didn't go to one of those top 20 law schools that even Trump apparently has a circle jerk session over. You know, they got to be from that. They got to be academics to be on the Supreme Court. I would love to see a country lawyer picked to be on the Supreme Court. It'd be freaking awesome. Because a lot of this shit would die. Department of Treasury, they're just going to keep giving example after example after example after example. And we're not going to read that because my eyeballs are starting to go. Let's see. The states have not carried their burden. So we're back. Here we go. My left foot. Why is Russell Greer coloring on my paper? This is crap. This is utter crap. Let's see. I wish I could get these texts to actually work on Rumble. This is really annoying. Let me see if all works again. Jefferson C. Post said, like you said, maybe you would have been the proper avenue. Yeah, class. I mean, the union. That's a good argument. What a class action. I don't think you couldn't do a class action. Are you talking about a protected class? Yeah. Country hanging judge. There's an affirmative defense. Speaking of that, in
I would never use it. You could Google it. It's real. I think the guy was alive up until about 2020. Last I checked, it was late 40s. He went to a grand jury. Before a grand jury, the guy killed some other dude for whatever reason. I can't remember. Fighting words, whatever. And Georgia called it, or he did, the some bitch needed killing defense. And it was a real thing, and it worked. The grand jury didn't indict the guy. Does anybody use it anymore? Well, of course, no. At times, yeah, sometimes you say that, like, man, some bitch needed to be killed. I don't know. Maybe we shouldn't indict him. But it would be great. In fact, speaking of hanging, the last state to do a public hanging was Kentucky. And I think in 1927, you can see Google it and you'll see the photos of it in Owensboro, Kentucky. If I'm not mistaken, it's Owensboro. I'm almost positive. I don't see. I'm getting on YouTube. This is interesting. Sorry, I appreciate you bearing with me, man. Got to get the right grand jury for that. Yeah. Oh God, grand juries are just. I'll be honest. I could. The old saying is, I could indict a ham sandwich, and you can indict a ham sandwich. It's not hard because the only people that get to appear is the state. That's it. They read the police report or they interview the cop, maybe the medical examiner, maybe. They show them the evidence for it. That's it. Done. You've got an indictment. It's not hard. Occasionally you'll get some kickbacks. Instead of a true bill, you'll have a denial, but it's rare. It's really rare. I think I've had probably less than a half a dozen in the thousands that I've done. There's a delay between the chat appears on YouTube and when I see Rumble embedded in the video. It doesn't surprise me. I don't understand why freaking StreamYard can't do Rumble. They do Twitter and all the other crap, but they won't do. I think it even does. I don't know if it does Kick or not. I think Rumble does Kick though. It's kind of cool. But it works the exact same. It's just there's some lag issues apparently. But I've never done multiple streams on StreamYard either because you have to pay for Twitter, and I'm not going to do that. It's not going to happen. It's not worth it because I think a lot of those are just. It'll say like 3,000 watchers, and it's like no, that's just people scrolling through. So. It lies. It lies a little bit. The states have not. Let's see. The states have not carried their burden, however, of showing a likelihood of success on the merits. The DoD, National Archives, and OPM. With respect to these three named agencies only, the states have not provided. The states have not provided any affidavits from, for example, former employees attesting to their terminations. So they don't even have that. They don't even have one. It's just them. Or to the presence of widespread terminations of probationary employees. So, damn it, Russell. God, this is bullshit. I have to keep fixing it. Termination of probationary employees. While the court does not rely solely on these affidavits for termination letters and reaching its conclusion, those records provide an important link between individual defense agencies and the broader allegation about the number of employees terminated and the general statements discussed above. So although it's a close call, I just don't think it was a close call for this judge at this early stage. And given that a TRO is an extraordinary remedy, which may only be awarded upon a clear showing. Where's my pen? Let me a little pen here. Let's try that. Clear showing. Oof, that's way too big. Yeah. Clear showing the plaintiff is entitled to such relief. There is insufficient basis in the record for the court to conclude that rifts likely occurred at these three agencies. This conclusion is without prejudice to the representation of additional evidence. So, I mean, obviously, they're going to have hearings to decide this, but they want the damn heads of the agency to testify. They're saying that they were contrary to the statutory RIF procedures, which, again, even if that's the case, they don't have standing. They don't even have a single affidavit. You've got nothing. You can't even defeat summary judgment. You've got no evidence. This is insane. This is literally legal. David Copperfield is what it's magic. That's all this is. It's just regurgitated magic to get their way. That's it. They just need some sort of a basis to justify their position. But the problem is, if you don't know the law, or if you're not impartial, you're not going to see it. We should have stopped at standing, period. It is undisputed, I can't even do that. Let me go back to the highlighter. That these requirements apply to probationary employees. It's not undisputed. It's disputed. The freaking government just said that. And they don't even really talk about the government's defenses. It's all about the offense. That's it. And they're not supposed to. They're supposed to take it and weigh both sides, and they're not freaking doing it. Whenever a RIF involves at least 50 employees within a competitive area, the agency must provide notice to the state. Here we go again. I should have just rebooted the app or the browser. That's annoying. Designated by the state to carry out rapid response activities. And we've already talked about what the notice is. The government did not follow the requisite notice of procedures and does not attempt to argue that it did, because it didn't have to. And there's no need to we don't even have to go that far. Because the states have shown that the government's actions were highly likely not in accordance with law, they are likely to prevail on the merits of their Administrative Procedure Act claim. Let's see what this footnote says. Although the court is focused on the lack of requisite notice, there is no evidence that the government followed any of the requisite RIF procedures. So they're using just a little bitty tweak of law to justify a mass injunction. That's all it is. Irreparable harm to the state? No, it's to a person. And again, there's no person here. None. This is all bullshit. This is stupid. This is just diarrhea words. That's it. That's all it is. Just diarrhea. Somebody went in there and just had like Kenny explosive diarrhea. I mean, that's all this is. Now we're going to talk about the scope of the TRO. The purpose of preliminary injunction is to preserve the status quo until there is a trial on the merits. Well, shit, that could be in 5 years. And that would be the point of them, to just delay. The purpose of a TRO is to preserve the status quo until the court can hold a preliminary injunction hearing. I guarantee you it still hasn't happened. Or if it has, they've already ruled in their favor, and they're going to have to take it to the appellate court, which we already know what's going to happen there. They're going to have to go to the Supreme Court, and those assholes aren't going to take it probably either, because they're sitting there beholden to sit on their knees with the damn deep state and provide enjoyable actions for them. I swear to God, they need to just disband the article. Just get rid of them. Just leave old Justice Roberts there to just hold the fort, and he can suffer. I'm sick of it. The government argues that an order reinstating fired workers would not be a proper invocation of the court's authority to restrain, rather be an impermissible mandatory injunction. The government is mistaken. A mandatory injunction, which is disfavored, flying, and issued on only in the most extraordinary circumstances, is one that changes the status quo. Okay. Probationary injunction or prohibitory injunction, by contrast, is one that maintains it. Okay. I swear. These damn judges. Critically, the status quo for purposes of injunctive relief is not the circumstances existing at the moment the lawsuit or injunction was request is actually filed, but the last uncontested status between the parties which preceded it. Okay, I mean that's not that's not wrong. Okay, fine. We're still not addressing I mean, if you notice, the standing issue was very quick, real quick, because there's nothing they can't cover it. They can't beat it. They can't do anything with it. As the Fourth Circuit recognized, it's sometimes necessary to require a party who has recently disturbed the status quo to reverse its actions, but such an injunction restores rather than disturbs status quo. But the status quo is that they're fired. That's not, I mean, as the Second Circuit explained, we can bypass those assholes. A soccer league, North American Soccer League. Oh, another gay sport. Actually, I enjoy soccer. I coach it too, but they're full of woke idiots. In the context of the broader conceptual distinctions between a prohibitory and mandatory injunction of Rule 65's use of the word restraining must be understood. TRO should issue only for the purpose of preserving the status quo. It's just supposed to go, okay, everybody just stop, take a breath. Just hang on. And you know what? He doesn't have to sit there and go, you got to restore them. He could just say, okay, hang on. They're not fired. They don't go back to work, but you got to pay them. That sucks. But I could at least swallow that because at least they're not in the damn deep state doing stuff like at USAID. Instead, the court is asked to order the government to preserve the situation that existed before it embarked on the likely illegal, they've already made a determination, mass terminations without providing requisite notice to the states. We're back to the state because he has to argue that. He can't say without providing requisite notice to the persons. It has to be to them. That's the only way to get them into court. I don't think it's going to be enough weight to get them all the way through, or especially through the Supreme Court. I could be wrong. It's a 50-50 split on that, man. Who knows? Although such an order will inevitably require the government to take affirmative steps to comply, it nevertheless fits comfortably within the scope of TRO authority. Geographic scope. This is important because it's 13 states. So why is it nationwide? This task is an exercise of discretion and judgment, often dependent on as much of the equities of a given case as substance of the legal issues it presents. Look who the case is. Imagine that. Another case where they've had to deal with the same bullshit. In this case, the district court or the Fourth Circuit upheld district court's entry of preliminary injunction, barring the government from enforcing an executive order concerning the refugee settlement that was likely violative of the Federal Refugee Act. The court held that the district court did not abuse its. I don't even know if my volume is good. I meant to ask you that like an hour ago. Jefferson, if you're still on there, can you tell me if the audio is okay? Which was the federal appeals court that actually stepped up and did their job in Dellinger. Let me check. I want to say the 11th, but I could be wrong. Let's see if I can find it. Against special counsel. Oh, that was the one. It was a DC court, but it went up and just kept going back and forth. Yeah, that was DC. It was the DC Court of Appeals, and then went to the Supreme Court, and then Justice ACB. ACB and Justice Roberts took a dump on it and sent it back, but the judge finally got. Okay, good, thank you. I appreciate about the volume. They took a dump all over it and sent it back, and they had to realize, or the judge finally realized and bitched and moaned that I get it. You're going to freaking overdo or reverse what I've done. The recent appeal involving Hampton Dellinger, former head of the U.S. Office of Special Counsel, was handled by the U.S. Court of Appeals for District of Columbia Circuit. This appeals court ruled that President Trump had the authority to remove Dellinger from his position, overturning a lower court's decision. Yeah, that was done after the Supreme Court had kicked it back with they had to decide a certain issue, and then they reappealed it because I think he still denied it. They issued that, and then the district court finally, I think before even the court decided it, he quit, if I'm not mistaken. Yeah, 10 days ago, at least the AP News says it, that he had quit before it. Yeah, so I hope that answered it. Let me go back to, we're almost done. We're almost done, chat. We're almost done. Yes. Thank you. Because this stuff is so hard to cover. Oh, it sucks. I'd rather be doing something on, like, I don't know, why a death sentence is appropriate. Yay. Heck yeah. I may even do one. You know, South Carolina just executed somebody by firing squad. Most people don't know this, but the country that executes more people by hanging than anywhere else that we know of on record is Japan. And I'm sure we could go and hire Usagi Yojimbo to come over here and set up a little, trap door for us and teach us how to do it. Boom! Get that taken care of. No more freaking drugs. Which, I don't know. I'd rather be freaking doped up and high on some barbiturate and taken out before I'm shot. But apparently, the dude died within seconds. So, and the Supreme Court refused cert. So, looks like that one's good to go. And Alabama apparently has really hit on nitrogen as a method too. So you just basically go to sleep, just get tired and go to sleep, and that's it. You're done. In the Refugee Act case for Trump in 2017, the court held the district court denied abuse of discretion in enjoining the application for the executive order nationwide. So here we already got an idea that he's looking at nationwide rather than just those states. Rather than limiting the relief to 3 plaintiff resettlement agencies. That's the way it should have been done. That's usually how it's done, especially if you're dealing with a suit with BATF. Excuse me, Fifth Circuit, like I said, originally just wanted to do Texas and then eventually expanded it to do the Fifth Circuit. And it stayed that way for several years. And it finally expanded it nationwide. I think it was Niagara that joined. It took several years for that to go through. It came down to the wire because they were going to enforce that damn rule. And like I said, a large majority, millions of those braces have been sold. So even at, let's just say, a bare minimum, 500,000. Where are you going to put the prisoners? What the hell are you going to do with those folks? It's like they don't even think it through. What they think is they can just scare us into just acquiescing. And unfortunately, most Americans do it. That's the sad thing. Much like how the program challenge in HIAS impacts refugees assigned to all 9 resettlement agencies, here the challenge dismissals without notice apply to federal workers spread out through the United States. So they're going to sit there and go, the injunctive relief needs to be made for the whole nation rather than limiting it and narrowly tailoring that to just the 13 states, which is all it should be done. Worst case scenario, just limit it to the 13 states. That's it. And it's not that many of employees. We just saw how many per state. It's not many. That's not their goal, though, guys. That's not their goal, chat. They don't care. They want to keep the state the way it is. They want the status quo to not change. Damn the consequences. Damn the general public's election results. Damn it all. We're going to make the decision. The factors governing issuance of a preliminary injunction also govern issuance of a 705 stay. Let me go back to that. That's under the APA. Under the APA, to prevent irreparable injury, the court may issue all necessary and appropriate process to postpone the effective date of the agency action or pending conclusion or rights pending conclusion of the review process. Factors governing issuance of preliminary injunction also govern issuance of a 705 stay. Furthermore, it's well established that the court may craft declaratory injunctive relief, that is true, designed to preclude a federal agency from acting in contravention of statutory and regulatory authority. That they are correct on. It may require an agency to modify its current or future practices in order to account for past violations of statute. The problem is that they're trying to usurp the Article 1, or excuse me, Article 2. That's what they're going to do. They're determined. They're going to do it. They're going to use Marbury v. Madison to do it. That's where it all comes back from. And the court has never, and they're never going to take authority from itself. That will never, ever happen. Trust me. I will grow 2 dicks before that happens. And that's not going to happen, obviously. Well, I guess I could go have a transplant, you know. I wonder what I would be called. I wouldn't be a man. Would I still be a man? Or would I be a man? I don't know. That's interesting. I may have to bring that up next time I get in an argument with some moron. Let's see. Let's go through here so we can get done. We've been doing this a while. Here the court finds just a vacatur would likely be the appropriate remedy. At the final judgment standard of the APA, the provisional remedy under Rule 65-705 is a stay of government's efforts to terminate probationary employees en masse without notice to the states. That is the only way they're going to try to survive this. That's it. They have to make it to the states. That's it. They've got to connect the dots. And I'll be honest. I mean, they've played some good legal gymnastics. I mean, they get a lot of courts to buy their bullshit. Absolutely. I don't think it passes a standing test. But I'm not a federal. Well, I'm not a federal judge, but that's not saying much. You know, I always tell people that people look at judges as somehow this elite legal mind, and I'm like, look, excuse me, they're just a dude or a chick. They have a law degree. They pass the same bar exam. Depending on the state, they may have a certain amount of experience, and they paid a filing fee to run for office and got lucky. That's it. That's what makes you a judge. And in federal, you get lucky enough to get appointed and confirmed. These people are not, geniuses. They're not legal Einsteins. They're just people. So, no, they're not any more brilliant than anyone else. In fact, there's a lot of non-lawyers that are just as smart. Drex used to think the Baldo was for being a madman. Oh, the man Baldo. The Baldo. Yeah, hanging is quick as long as they tie it right. I recall they didn't with Saddam. You're right. I forgot about that one. It's funny you say that, because if you go back to the Nuremberg trials, the guy that did that was Britain's high chief executioner. He was a hanging guy. They had hemp rope. He had to, soak it, stretch it. There was a lot of things you have to do, not just calculation of weight, etc. But the guy was good. And apparently they left after about a year, and unfortunately left it to American MPs, and we suck. So a lot of those guys, let's just say they hang there a while. And in fact, some of the cases, the MPs would have to jump on the guy while he's hanging, and they unalived quite a few with their heads separating. Yeah. Not that I care. I, I'm a little psychopathic when it comes to that. I don't care. These people, some bitch need to kill him. I mean, I hate to say that, and YouTube will probably strike me for it. Thank God I'm on Rumble, so at least something will stay up. The Baldo, God, I can't believe Aaron got away with a $50 fine. I had a case once with it was it at? Was it? I can't remember. It was Calhoun County. Yeah, it's irrelevant. But anyway, it was a juvenile. It was about dissemination of material harmful to a minor. It was pornography. And you had a 14, 15-year-old girl doing her little self-nudies, little titty shots. And she was sending it to another juvenile boy. Well, what do boys do? Get nudie pics. We're going to freaking share them. That's what they do with Playboys. This is what happens. This is what boys do. We suck a bit. We're women don't understand it, but that's just us. And what sucked was these kids, unfortunately, texted it to an 18-year-old guy. And yeah, that guy, he got screwed. But they had even charged these juveniles with these sex offenses. And even more perverted is that the young lady who was only 14, 15 years of age, they charged her for harming herself. My grandmother's uncle. A lot of them did. A lot of them got to go home. They weren't all, people don't get it. They weren't all Nazis. A lot of, you've got Guderian, Manstein. They weren't Nazis. In fact, there's a great book to read. It's called A Higher Call, and it's about two pilots, Captain Charlie Brown. It's more about the German pilot, but he was a B-17 pilot, and he was doing a raid over France and just shot the hell up. I mean, his gunner was hanging out of the turret. It was bad. And a Messerschmitt, a guy in I can't think of his name for the life of me, but he came up behind him in a Messerschmitt, was it BF-109? And instead, he said in his in the book, he recalled, he said that his commanding officer had told him, if I even hear of you shooting a guy in a parachute, if I ever hear that, I will shoot you myself. And that honor code, he looked at that plane as the same. It was actually in the 100,000 between the wars. Wow. He looked at it, and so what did he do? He wasn't a Nazi. He was just an enlisted sergeant. That's it. I think he was a corporal at the time. The Germans allowed you didn't have to be an officer to fly in Germany. I don't know about now. Instead of shooting the plane down, one burst would have done it. I think they had like an engine left is all they had. And they were crossing, the Atlantic Wall. So they were going to get shot down. I mean, the silhouette was enough. And instead of shooting them down, he flew next to them. And he pointed to the right, And Charlie Brown, he's like, later, like 40 years later, he's like, I don't know what the hell he's pointing at. He's like, what are you talking about? I don't know. What are you pointing at? I don't know. And it turned out he was pointing for him to go to Sweden. So that way was, to the right was Sweden. Just go that way. You're closer. You'll make it. And then you can be interned and you won't be hurt. And instead, he kept going. And so this German pilot went halfway across the channel with him because he knew his outline was a German plane, it was unique, and the Germans were not going to fire. They just weren't. And of course, he could have been executed for that alone, but he got Charlie Brown home and those boys. And they eventually met up 40 years later in the 80s and were friends until the days both of them died. But this guy's story is amazing because even later in the war, when all was bleak and they were finally using jets, he said that they would get new recruits or whatever sent to their Luftwaffe, detachment or whatever, and they would test them with a salute. And it's so the officer would, pop a salute, and if they did a Heil Hitler, they were gone. About 24 hours later, they'd have some bullshit excuse of he's incompetent, he's just dangerous, etc. So my point is, not all of the Germans were Nazis; they just weren't. What an Uber Chad? Yeah. It's a heartwarming story. I'm not gonna lie. But that was common. And then my granddaddy had a best friend who was he was I think 82nd Airborne, and I can remember I'll never forget. I can remember a Luger and a yeah, it does go to that theory. Yeah. And unfortunately, the Brits were the ones that did the mass bombing. That's what we eventually started to do. They did. My wife's granddaddy was a bomber pilot, and he's all the blackout dates for like the bombing of Dresden, Leipzig. They're blacked out, but then all of a sudden you look at his flight logs or whatever when he was flying missions, they're blacked out. He was also one of the pilots that bombed the bridge at Remagen for the colored troops to actually be the first ones to cross into Germany in like 1,000 years. So I mean, it sucks, and he had a hard time dealing with that, the firebombing. The day he died, I think he told her, they've got him on tape recording, that he thought it was terrorism, terror. It was horrible. Phosphorus melts you into the asphalt. It's that bad. So, I'm not going to go back and look at history with rose-colored glasses. I'm just not going to do it. I think the atom bomb was probably needed. We would have lost 1 million in casualties estimated trying to invade Japan. So anyway, I'm sorry, we're getting off subject here. I'll do that all night long, and I'll talk about the Second World War all night long. Go back to the court here. We conclude the scope of preliminary relief under Section 705 aligns with the scope of ultimate relief under 706, which is not party restricted and allows the court to set aside an unlawful agency action. If you're wondering what this is, where there's no marking, no numbering, the WL, that means Westlaw. It's not necessarily unpublished. It's just not yet, and it's done through Westlaw. And that's how you would look it up. But it hasn't been assigned. Like, it's not in the Federal Reporter. I think they're on the 3rd. So it's not in the Federal Reporter yet. It's an opinion, and it's in Westlaw. That's it. But they don't even have the numbers listed. So that's what they do. I think that looks like a memorandum is all it was. Nationwide preliminary injunctive relief guarantees that a rule shown likely to be proven unlawful does not become effective, providing complete relief to the plaintiffs while the rule's legality is finally adjudicated. So basically, they just want everybody to go back to work. Screw you. We're going to delay it till he leaves office. We're going to win. That's it. That's the game plan. That's obvious. I still think the court's going to hit them on standing. I don't know. I may be wrong. I'm hoping so. I don't know what other law tubers are going to say. I don't know. I don't even know if Sean went over this yet. I may have missed it. I'd be interested to know what he says. Potentially criminal. Only an order stating the government's likely unlawful RIF process can prevent states. We're back to that again. They have no other argument except the states. The states, the states, the states. That's it. Not the people. Under the disruption and cost of the mass terminations. That's not enough. That's not enough. Like I said, most of those unemployment benefits are paid by the federal government. The feds pay for it. Where's the harm? What's the harm? And a lot of them may not even get it. Were the court to withhold granting such interim relief, it would likely be impossible to adequately remedy the state's final injury of the stage. So that's what they're going to say. They're going to say the states are the ones being harmed, not the people, but we're going to protect the people because the state's being harmed. That's the bullshit logic. They literally, this is in any other normal circumstance, this would be a denial. You'd be out the door, period. The court is not blind to the practical reality that the relief being ordered today will have far-reaching impacts on the workforce. Ooh. So you actually care and will require the government to expend considerable resources, but we know they have tons of money they can just print anyway, so it doesn't matter. But as explained above, the scope of injunctive relief is dictated by the extent of the violation established. Blah, blah, blah. Agency restrained. I guarantee you, I'd be shocked if it's not the whole government. Maybe not. There are 3 agencies named as defendants. It is, of course, axiomatic that a movement is not entitled to a TRO against a defendant when the movement is shown likely to prevail on the merits. This exclusion is without prejudice to states' rights. It just dumbfounds me. Any other day, a Democrat would say, "To hell with states' rights. It's the federal supremacy. Federal supremacy." Not now, because it benefits them. Sometimes that's a double-edged sword. The states' rights is a double-edged sword. But that's the way it's supposed to be. The Constitution is supposed to be that way. You take the good with the bad. At the preliminary injunction stage, to produce evidence showing that rifts occurred at these agencies and to seek appropriate relief. Security or bond. Oh, that's hilarious. They're going to make them have a bond? Are you freaking kidding me? Really? Oh, freaking A. You're joking. This never happens. Normally, when you appeal or do anything and you need a bond, let's say it's I don't know, a judgment of $1 million. Well, if you want to stop enforcement of that action, you better have $1 million to post. You better have it. That's it. It's not like a bondsman bond. I'm sure there are those that would, with the right amount of money or whatever, would do a 10% or 20% or something. But you got to post that money with the court just in case you lose. They get that judgment and it's enforceable, and you're not using it as a delay. Accordingly, the court will require each plaintiff state a $100 bond. That's it. So they're protecting the states, protecting them, and a $100 damn bond is all they got to put. This is a scam. This whole thing's a scam. Stay pending appeal. I wonder if they even gave him a stay. Logically inconsistent for court to issue a TRO and then stay that order. So no, you're not going to stay it. So it's going to go into effect. The government, Trump has no, they're backing him into a corner. He's going to have to grow a pair of nuts and say, enforce it. Good luck. Enforce it. What's the judge going to do? When it comes down to it, think about it. Even on a state level, when the governor's in control of law enforcement or the attorney general, if they're not going to cooperate and they're told you're not to do X, no matter what a judge says, you are not allowed to do it. And the sheriff's deputies and the sheriffs comply and the state polices or whatever state police you've got. I hate that term. what's going to happen? The court doesn't have its own police. There's a reason for that. They don't have it. There's nothing that can be done except by acquiescence. They say do it. Government goes, well, okay, George. And then they get, the police to go, okay, all right, Judge. Yep, you give a lawful order. I'll follow it. I'm just following the order. That's it. That's their argument. It's just the order. But what are you going to do when they say the opposite? There's nothing. This is one case, or 2 cases, probably more, where the damn president needs to say, I'm not doing it. Go fuck yourself. Go fuck yourself. He should write it on paper and fax it to them, or just have someone deliver it by hand. And I would use those words. What's he got to lose? He ain't got nothing else to run for. Pending appeals during the 13th day of March. For these reasons, TRO will issue James K. Breeder, or Bredar. It's a little my left foot signature shit. I'm going to do that there. This is an ass clown. These guys, they're ass clowns. But there's nothing we can do. There's nothing we can do unless the president does his job and protects us. That's all we can do. It's I heard the planes smell like awful barbecue after those bombings. Yeah, that's what I've heard. I've heard that too. In fact, the pilot said that it was bad, really bad. And I don't know. I'm not going to judge them. I'm not going to judge them. Everybody wants to say, oh, they were like Tucker Carlson. Oh, they did terrorism. Or violated the war, rules of war. They did what they did to end it. If we hadn't have, I think it's estimated by those people, historians, that had we not done Lend-Lease for the Russians, they wouldn't have gotten to Berlin in May of 45. It was more like 46, because you got to remember, we gave them the deuce and a half trucks, everything that was motorized. They didn't have it. They were on horse. So you would have had 2 armies. The German army was mostly horse driven. So you would have had those 2 fighting. I think I'm talking to nobody. Oh, wait. Got somebody back. All right. Well, sorry, whoever's joining me on Rumble. And I hate that I can't figure this out. I hope this has worked tonight. I hope it has. If you're on here, guys, let me know if this one comes through. I'm hoping it comes up. It still looks like it's coming up with my account name. That's very bizarre. It didn't do that at the beginning. It didn't. That's weird. Test again. Yeah, still coming up with my account name. Oh, that's weird. It should be coming up as Bama Law. I don't get it. Oh, well. I've tried to fix it. There's always issues with this shit. I know. Good, you're still there. Good. Yeah, I don't get. That's so weird. If I do if I text it directly to YouTube, it comes up as my channel name. That's really peculiar. So, y'all have any requests or anything you want to cover for the next time? I'm trying to remember what the hell I was going to do the next time. Besides this, let me see. I may have it saved. No. I've done the 14th Amendment. I did the ARC case, which is what they're going to go on based upon. I think I may do one of the newer TROs or whatever, where the court's trying to make them resettle these illegal aliens. That, or I may do a death penalty overview on the new means of execution. I don't know. Maybe one of those. I thought about doing some military UCMJ stuff. I'm not sure, but I think it would be kind of cool. Would y'all be interested in domestic law shit? Yeah, your chat popped up at the top of this. Yeah, I'm starting to see issues. Yeah, on this end too. It's not perfect, but my real reason for doing this, I can see on analytics, YouTube does like your first video or two, man, they bust it. You're just poof, thousands will see it. And then slowly, and I think it's their algorithm, it'll dump. And then you might put out, I don't know, 30 videos. And then all of a sudden, out of nowhere, on like some silly ass video that I'm like, and maybe it's just, maybe it's just the way it is. I don't know. But it'll be something that's like, man, nobody cares about this. This sucks. And it'll spike again. And then it will come. It's very peculiar. And I think I'm seeing a lag here too. But I think that's my computer. I'm using an old iMac with a hack copy of Mac OS. So maybe that was a highlight function. Yeah, maybe so. I don't know. It's really peculiar. Yeah, I don't know. I was really hoping this would like totally work, because I mean, obviously, I don't want everybody to see my freaking account name. I mean, it's not that I care. I really don't, but it's confusing to people to come on and go, "Oh, Bama Law. Oh no, who the hell is this dude?" But I may not be able to fix that. I don't know, because I changed it, and looks like it's not fixing it. It started off as Bama Law and changed somewhere along the line. So anyway, you say what interests me is most sustainable? Yeah, probably so. Yeah, probably so. This one, I think we're in for a haul. I really do. I think I think we're really in for a haul. I was gonna do the Second Amendment progression from Heller to Bruin, but that's kind of been beaten to death, I think. So I don't know what I'm gonna do next. I'll have to figure it out. I may cover one of Destiny's next pleadings. He's screwed himself. His lawyers can amend it, their answer, but if they don't, they're going to waive their defense on those questions that potentially criminal pointed out. Was it last night? Night before? Last night. I think it was last night. So I don't know. I think Baldo's done. So we'll have to see whom else we can go after. I'm sure there'll be another pedophile to highlight or something. It's inevitable. Okay, guys. Well, I appreciate. Thank you all for joining me. I appreciate it, because I suck at this. It's new. I lost. I don't know what happened. Thanks, man. It just crashed on me. Thank you for joining me. I freaking suck at this. I'm new. Thank you for there's a dismissal they're waiving. Was it? Yeah. Yeah, no, yeah. They're gonna several counts. They're gonna have to wait. Yeah, it's if they don't amend it by I think it's the 18th. They can amend their answer within the 21 days of service. Otherwise, yeah, they're screwed. They're done. It's waived. It's 11th Circuit. It's the same as they have a little bit of a little. It's weird. The 11th Circuit, it's Alabama, Georgia, and Florida. if you go to the 11th Circuit and you practice in any of the district courts, like for instance in Alabama, it's not any different than the state rules. But each state, the federal courts have the ability to do local rules. So anyway, thank you so much for joining me. I really appreciate it. Thank y'all, and y'all have a good night. And remember, it's a club and you're not freaking in it. That's the problem. Y'all have a good night.